Here's the date and time set for a competency review here. Does the court have an updated review?
I have a report from January. Is that our most updated one?
That should be the most updated one.
No, excuse me.
Yeah.
And they said I was found competent. Forensic.
Now, we have no further evidence to present. The January should be.
A tether violation. The allegation is that he was in the vicinity of the alleged victim's home. I believe currently there's a 2-mile hot zone around that particular location in Jackson. What Mr. Parkus tells me is that he too is a resident of Jackson and had been going to a store that's in that location, which is what caused the tether to go
He was
off.
within 150 feet of the exclusion zone.
Your Honor, that's what he's telling me. Is that
Okay, go ahead.
I don't know how accurate these tethers are and how close he was to the alleged victim's home.
In Judge Simpson's courtroom today, we have 2 cases that pose challenging questions about competency and adherence to court orders. In our first case, we encounter a defendant who has been deemed competent to stand trial, yet there is undeniable uncertainty lingering in the air. Despite the official assessment, there's a sense of unease surrounding this individual's demeanor and responses to questions. And in the second case, attention turns to a defendant who finds himself in hot water for violating the terms of his bond. With a GPS monitoring device revealing his proximity to a restricted area, the defendant stands accused of breaching the court's orders. As Judge Simpson weighs the severity of the violation, one question arises: will this transgression warrant the revocation of the defendant's bond? Stay tuned to find out.
Are they there?
I can keep.
Huh? I don't see anybody. Oh, there they are. Court calls case of the People versus Christopher Page.
We're ready in that matter. Long Brown Deputy Chief Public Defender appearing with and on behalf of Mr. Page, who is approaching the podium from the lockup. Eventually. Slowly.
Christopher Keith Virgil Page.
Here's the date and time set for a competency review here. Does the court have an updated review?
I have a report from January. Is that our most updated one?
That should be the most updated one.
No, excuse me.
Yeah.
And they said I was found competent. Forensic.
Now, we have no further evidence to present. The January should be.
Any other additional evidence from the people?
Thank you.
Based upon a review of that report, the defendant is no longer incompetent to stand trial, can specifically understand the nature and the objects of the proceedings against him, and can rationally assist in his defense. Therefore, the defendant is deemed competent.
Thank you, Your Honor. We will prepare orders to that effect. We are respectfully requesting a probable cause conference date at this time. Yes, so we can move forward.
Well,
Set a probable cause. I'll set a probable cause conference for March 7th, 2024, 9 a.m. Bond will continue. Thank you.
Very good.
Court calls the case People versus Ryan Ellis. You know, whenever anything happens like that, Feaster is gone. He's like back in the audience playing and everything. He's like, I'm not part of it. Then once it's gone, he appears back.
Assistant Public Defender Jay Bellinger on behalf of Mr. Ellis, who appears before you, Your Honor. And Mr. Ellis, can you please state your name for the record?
Brian Ellis. Okay, good morning. All right, what are we doing?
Your Honor, we were asking for an adjournment until about mid-March. I've talked to Mr. Childers to see how we can progress with this case. He's agreed I mean, I can let him address what our plan is if he can do it more eloquently than I can right now.
I'm sure that would happen.
Yeah.
I don't know. I need to know that
That's
right now.
fair.
March 14th,
Thank you.
2024, 9 a.m. bond continued.
Get it.
Thank
All right.
you. Okay, so the people versus, is it Dalen Parkus?
Attorney Morgan Barosa on behalf of the people.
And good morning, Your Honor. Andrew Meyer on behalf of Dalen Parkus. Mr. Parkus, could you please state your name for the record?
Dalen Parkus.
Sorry.
Okay.
Your Honor, this is the time and date set for a probable cause conference. We are requesting the court set this for the next available preliminary exam date.
You want to address his violation?
Whichever order the court wants to take it in, I'd be happy to address that first.
Go ahead.
Your Honor, it's my understanding that Mr. Parkus came into custody yesterday evening on a tether violation. The allegation is that he was in the vicinity of the alleged victim's home. I believe currently there's a 2-mile hot zone around that particular location in Jackson. What Mr. Parkus tells me is that he too is a resident of Jackson and had been going to a store that's in that location, which is what caused the tether to go
He was
off.
within 150 feet of the exclusion zone.
Your Honor, that's what he's telling me is that.
Okay, go ahead.
I don't know how accurate these tethers are and how close he was to the alleged victim's home. What Mr. Parkus tells me is if he were to be released, he would return to his aunt's home in Jackson. She lives far enough away that there won't be any further problems with its tether. He is currently employed. Your Honor.
Go ahead.
Okay. He is currently employed at an auto parts manufacturing plant. He's had that job for the last 2 months and he would like to return to it. He also has a 4-month-old daughter who's currently residing with his mother. Mr. Parkus is 19 years old. I know that he wants to bring this case to a resolution as soon as possible. I think his desire here is just to set this for an exam, determine what will happen. I don't think there was any part, at least from what I'm seeing here, any indication that he was intimidating or trying to prevent the alleged victim in this case from coming to court or anything along those lines. So I would ask the court to consider re-releasing him on tether and setting this for an exam.
Response from the people.
I do want to note for the record that an offer for misdemeanors was formally extended for the defendant to plead to counts 2 and 3 as charged. In exchange, count 1 would be dismissed with an agreement to $240 in restitution. So if you wanted to get this case over and done with, we could do that today. If that is not the case, and he wants to proceed to exam, we are ready to proceed and we would be happy to set it. I would object to setting his bond back to where it was. It was set at $5,000 cash or surety. We did request $250,000 initially in this case. That is because this occurred at Mott's Children's Hospital, where the child was being treated for non-accidental trauma. CPS is involved in that, but the defendant strangled the victim at Mott's and then stole her phone. When she was trying to get the phone back, he threw it into the sewer. He admitted to taking the phone. The victim had red marks around her neck. And the defendant made statements as to the red marks around the victim's neck, even when officers did not ask any specific questions about that. We are significantly concerned about the nature of the allegations, about the fact that he was so close to the victim's proximity, despite having a GPS tether on. We also do want to note that the victim reports that the defendant, this was not the first incident of an assault between the defendant and the victim. In her words, she said the defendant assaulted her many times in the past, including times where, as a result of the assault, she became lightheaded. this appears to be a very high lethality situation. I understand that the defendant is young, but this is a strangulation, and it occurred in a place that is very public. So that does not appear to be any type of inhibiting consideration for the defendant either. So we do not believe that he is safe to be out of custody.
Anything else, Mr. Meyer?
Your Honor, all we have is this tether violation. If there was more, I think the state's concerns would be founded, but I think all we have is that he's somewhere in the proximity, which he could have been for any number of reasons.
Well, except for the fact that he was released on that tether around mid-December. And you're right, we don't have anything else, which is why I don't believe his story that he's all of a sudden in the proximity of a store that he regularly goes to, because that would have happened well before now. Is all of the discovery complete?
I believe so, yes, Your Honor.
Discovery is complete, and witnesses would be available on the 5th.
Yes, Your Honor.
So first thing I'll do is I'll set the preliminary examination March 5th, 2024, 9 a.m. That would be before Judge Perry. And at this time, given the bond violation, defendant's bond will be revoked pending that hearing. Thank you.
Thank you, Your Honor.
Court calls the case People versus Davion Gavin.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video.